Oh, and did you say we were expecting about 100 on the reservation list?
Is 135 as of 2 hours ago.
Wow.
And Mark, by the way, I am starting as the first speaker, if you didn't know.
Okay. We'll give it a couple minutes, see if more people populate and get going. Okay, I think we can probably begin. Welcome everyone. This is the real estate subsection of the finance subsection of the real estate section of the LA County Bar, one of their most popular seminars. My name is Mark Hyken. I'm an associate at Sklar Kirsch. We have a great panel of attorneys to discuss recent developments in the law of real estate finance. Scott Cooper is a partner at Mayer Brown. Alex Davis is an associate at Mayer Brown. Owen Gross is a partner at Sklar Kirsch. Ira Waldman is a partner at Cox Castle and Nicholson. And Amanda Woolen is an associate at Cox Castle and Nicholson. They've got a whole bunch of information to share with you. This was originally scheduled for the spring, and coronavirus interfered with that. And so now they've updated their recent developments to be timely. And so without further ado, I'll turn it over to Owen.
Hi, and welcome. Sorry we can't be in person. We definitely enjoy doing this presentation in person so we can have a little bit of back and forth with the audience as we go through. Unfortunately, this year, that's not possible. We are going to be checking the comments and Q&A sections. We'll try and do that fairly regularly to see if anyone has anything that they wanted us to address or a question on something that we said. And if we can, we'll try and break in and answer that. But if not, we can certainly make some time at the end and answer some questions as well. As Mark said, this program was delayed, like many programs, because of the pandemic. And so what we thought we would do is adjust our materials to include pandemic topics, and that's what I'm going to do. Is I'm going to start off with my experiences related to the pandemic, and then also segue into a couple of pandemic cases, and then we will go from there to hit on the rest of the big topics that we thought merited being talked about this year. To that end, we did provide you with 42 pages of summaries of various cases and statutes that we thought were relevant to continuing your practice in real estate finance since our last presentation. And so what we're going to talk about is covered in those materials. And what I'm going to first talk about starts on page 2 of the materials. And so essentially, you know, when everything hit the fan, I started getting calls from my borrower clients wondering, you know, what to do. And so I figured I would sort of talk through those calls that I had sort of in the order that I started getting them. And for the most part, I'm talking about calls from borrowers who had traditional CMBS loans or other non-recourse loans. And so the first calls were, hey, my tenants aren't paying rent. What happens if I can't make my debt service payment? And so the answer to that was basically, look, if you've got a non-recourse loan and you can't make your debt service payment, you're going to be in default, but you're not going to have recourse liability for that default if you do everything correctly, because this default is not your fault. It's not something you control. But that being said, you got to be wary of what happens as a result of that event of default. And so the first thing that I would mention to them is that if you don't have cash management provisions that are already effective from the origination of your loan, or maybe you failed a debt service coverage ratio or some other financial test between origination and now, an event of default is definitely going to trigger your cash management provisions. And so you're going to have to be ready for that. You may have an account already set up, or you may not. But if you don't, you're going to have to set up a cash management account, and all of the revenues from that property, you're going to have to send out notices to your tenant, are going to have to go into that cash management account, and then the lender's going to hold them. And the other thing you need to be aware of is that most recourse provisions in your loan documents say that from and after an event of default, if you misappropriate any of the revenues from the property, there's liability, recourse liability for that as well. And there are also some loan documents out there that basically say if you don't promptly get your cash management account open and send out your notices to your tenants to make payments to the cash management account, that also can result in recourse liability to the extent that the lender suffers losses from that. So the important thing is that at this point, when you are in an event of default, you want to be very, very careful that all revenues from the property are going to the lender and not in your pocket, because anything that goes into your pocket, that's a misappropriation, and that is possible liability. The second call I would get then is, hey, I've got tenants coming to me wanting to renegotiate their leases, and understood, like you as the borrower, no fault of your own that you can't make your loan payment, no fault of their own that they can't make their lease payment. And so many of the borrowers wanted to work with their tenants to keep them there for the long run. The big trip here is that under your recourse provisions in your loan documents, there may be major leases that require lender consent before you can do anything in terms of a modification. And so it was really important to the borrowers that they look at their loan documents, look at the definition of what constitutes a major lease. And then if one of your tenants under a major lease was coming to you for a modification, whether it was just for forbearance, deferral, what have you, you need to, before you sign up a modification with that tenant, get the lender's consent. Otherwise, again, potential recourse liability. So then after the pandemic had taken its toll for a little bit longer, I get another call saying, hey, I can't pay, for maintenance. I can't pay property taxes. I can't pay insurance premiums. Now, part of the reason they may not have been able to pay it is because the lender has all the money from the property, okay? Because they're holding in the cash management account, and, look, some cash management agreements provide for payment of property expenses first and then debt service, but others provide for debt service first and then property expenses. And in most cases, if it provides for debt service first, payment of debt service first, there's nothing left over to pay for property expenses. And so the worry here that you would have under your recourse for provisions is there's usually recourse liability for waste at the property or failure to pay property taxes or insurance premiums. And usually it's recourse liability to the extent of losses rather than springing recourse, but nonetheless, it's potential recourse liability. Now, there are two options here. First is you have well-negotiated recourse provisions, and they carve out from all three of those, waste, property taxes, and insurance premiums, liability to the extent that revenues from the property are insufficient to pay the same, or that if there are revenues available, the lender's not making them available to you because they're exercising some sort of remedy. So in the event that your recourse provisions already have that language, you're in pretty good shape. Otherwise, you may have to come out of pocket, or you can negotiate with the lender to change the way that the cash management funds are being distributed. And there's also, with respect to waste, sometimes it's modified to be intentional physical waste. And certainly if all you're doing is not paying for maintenance because you simply have no money to pay for it, it's hard for a lender to argue that that's intentional. So those are what you want to sort of be careful of there. A little later on in the process, and I started getting calls from borrowers asking if they could get a PPP loan or a small business association loan, and both have been readily available during the pandemic. And so the issue there is there are usually restrictions on obtaining additional debt. Sometimes they're in the recourse provision itself. Sometimes it's tucked away in the SPE provisions that your borrower has to comply with. And then a violation of the SPE provision is in the recourse provisions. And unfortunately, in both instances, the SBA loans, at least the ones I've been working with, and certainly not an area of my expertise, are both secured and have long payment terms. And the PPP, in theory, has a long payment term, although it can be forgiven. But nonetheless, it's additional indebtedness. It is characterized as a loan. And most SPE provisions and or recourse provisions restrict a borrower's ability to get other debt to trade payables and other unsecured debt that's payable within 30, 60, 90 days. And unfortunately, in neither SBA or PPP loans fall into those categories. So again, just like modifications of major leases, you need to be really sure that you get lender's consent, because in many instances, a breach of the SPE provisions is full springing recourse. Now, some of those full springing recourse for breach of an SPE provisions are limited to only if it's a breach that results in consolidation, which this wouldn't, but there could still be liability for the losses. Then as I got even further in, the next call was, hey, how do I contest the remedies that my lender is trying to go after for this event of default? And certainly the one you don't want to do is bankruptcy if you are trying to avoid recourse liability, because that's going to trigger full springing recourse the minute that you do a voluntary bankruptcy. Involuntary bankruptcy, you may have some time to cure, but as far as contesting a lender remedy, voluntary bankruptcy, bad idea if you're trying to avoid recourse liability under the guarantee. I've also had an issue come up where a lender wanted the borrower to consent to receivership. And under the loan documents, clearly the lender had the ability to get a receiver. But in some states, you have to jump through certain hurdles to get a receiver. And so the lender was trying to get the borrower to consent, affirmatively consent, to avoid some of those hurdles. And the question is by being passive, is that still contesting or in some way impairing the lender's remedies? And I don't have a great answer for you on that. As borrower's counsel, I'd certainly argue that it isn't, because they still have the right to get a receiver. Lender's counsel might take a different position. So, and then the one last thing that I wanted to just mention is, and probably a bit of this is passed already, but it is really important to get a pre-negotiation agreement before you do anything in the terms of start talking about modifications or whatnot. Because when you go to a lender and you start talking about why you need a modification, it would be really easy to say, hey, I don't have any money, I can't pay my debts as they're coming due. And that smells and sounds and quacks a lot like insolvency. And insolvency is another SPE requirement, that you can't be insolvent. And that again could trigger recourse liability. So I would just caution that if you get a pre-negotiation agreement, when you say things, write things like that, it can't be used against you by the lender, and it helps you avoid recourse liability for the breach of that SPE provision. So that again, been my experience. With that, I'm going to quickly move on and talk about a UCC foreclosure case out of New York, from the New York Supreme Court. And that involved a fairly typical mezz loan structure where you've got the mezz lender. The atypical part is the mezz lender was an affiliate of the construction lender. The construction lender, the construction project was behind schedule and over budget. So the construction lender made a mezz loan to an affiliate, the subsidiary of the senior borrower, and the mezz loan was secured by a pledge of the mezz borrower's membership interest, 100% membership interest in the property owner. The property was a 161-key hotel project in New York City. So the mezz lender declared a default and elected to do a UCC foreclosure of the pledged interest. No one contested that there was a default. What was contested is the mezz borrower contested whether or not you could actually hold a public foreclosure sale of these pledged membership interests during the pandemic. And they had two concerns. First, whether or not you could even get bidders to the sale. And second, there was a moratorium imposed in New York by executive order of the governor that prohibited foreclosures of commercial property for 90 days from March 20th to June 20th. The mezz lender asserted that the foreclosure shouldn't be stopped because, unlike other commercial property foreclosures, the UCC foreclosure is not a judicial foreclosure, and the moratorium, the executive order, said that there would be no enforcement of commercial property foreclosures. And so they were arguing that it clearly meant that if there's no enforcement in a non-judicial process, it couldn't have applied to non-judicial foreclosure of UCC under the UCC. And ultimately, while there was a temporary restraining order issued halting the sale as originally scheduled for May 1st, by May 7th, the executive order was changed to only apply to foreclosures of commercial mortgages. But nonetheless, the court still came out and said that the mezz lender was correct, that the initial moratorium only applied to enforcement of foreclosures. Because there was no enforcement, the UCC sale could proceed. And the biggest unresolved issue is again, how do you have a commercially reasonable foreclosure sale, public foreclosure sale, in the time of a pandemic, when in order for a UCC foreclosure sale to happen, a public one, you have to have multiple people coming together. And this court basically said that if there's an issue with it, whether or not it was commercially reasonable or not, we can deal with that after the sale. And if you think you were damaged because of the conditions that occurred at the sale, you can bring a suit for damages afterwards. Now, Amanda is going to report on a different case where the judge took a different approach to a foreclosure sale.
Thanks, Owen. So yes, as Owen noted, borrowers are in financial distress as a result of the pandemic. Loans are in default as a result of that, and lenders, both mezzanine and mortgage lenders, are looking to foreclose their loans. But those lenders should be careful. So with respect to mortgage foreclosures, there's no federal foreclosure law. State law serves as the law of decision in foreclosure actions. Some of the states have issued, many of the states actually have issued rules or bills that have attempted to give borrowers in financial distress some relief. For example, in California, the Emergency Rules of California Rules of Court were issued on April 6, 2020. Rule number 2 actually suspends judicial foreclosures. It stays all proceedings to foreclose until 90 days after the pandemic state of emergency is lifted. So that would still be in effect right now. There are also a few pending bills, one of which is Assembly Bill 2501, which would implement a 180-day stay of foreclosure, and AB 828, also pending, would create a moratorium on recording notices of default and notices of sale for foreclosure of residential properties. So there's no California case law on point right now, but as Owen noted, I do have a case to report on, and that comes from the United States District Court for the District of Hawaii. In that case, it involves a residential property. The borrowers eventually defaulted on their loan, and the lenders sought to foreclose. The borrowers argued that the lenders didn't have standing to foreclose and that they didn't meet all of the requirements to foreclose in Hawaii. The court actually found in favor of the lenders and issued a decree of foreclosure. However, the court then held that it would be inequitable to proceed with a foreclosure given the existing conditions, namely the pandemic. In reaching the decision, the court stated that, quote, in view of the ongoing COVID-19 pandemic, the government shutdown and stay-at-home order, the common law duty to obtain the best price for the property, and the fact that the real estate market is inactive and Hawaii has temporarily halted evictions, the court found that it would be inequitable and not in the best interest of either party to proceed with the foreclosure sale under the existing conditions. So the court held that the lender would be permitted to proceed with their foreclosure sale after the court issued an order recognizing that the threat of the virus had passed. So this shows that mortgage lenders should be careful in approaching their foreclosures. Even though they may have the right to foreclose under the loan documents and under state law, it might not be reasonable or or equitable at the time. And as Owen noted, this could be deemed to apply to mezzanine loans as well, because the UCC actually provides the protection that the sale must be commercially reasonable. It does seem hard to fathom how a sale could be commercially reasonable if meeting place gatherings are limited and all of that stuff. So even though that court did, the mezzanine loan that Owen reported on, even though they concluded that the foreclosure sale could go forward, they did also note that the lender could be liable for damages if it was later deemed to be commercially unreasonable. So I think we're going to see a lot more of this argument for a pandemic pause on foreclosures, both mortgage and mezzanine, and so we should advise our lender clients accordingly.
All right, Alex, you're going to report on the wonderful Black Sky case. And I will also point out quickly that later this year, or maybe it's early next year, Dennis Arnold will be doing a full presentation on UCC foreclosures and what is or isn't commercially reasonable as well. Alex?
Great. Thanks, Owen. So I'm going to talk about a recent California Supreme Court case called Black Sky Capital versus Cobb. This came out last year, 2019. And what it is, it's a California Supreme Court case that significantly changed the rule that a junior creditor cannot seek a deficiency judgment on its junior note after it had already foreclosed on a senior deed of trust that it held on the same property. So what we're talking about here are situations where a lender has multiple deeds of trust on a single property in a senior and a junior position. So first I'm going to talk about what the new rule is, and then given the importance of this case, I'll just go take a brief overview of the cases that led up to Black Sky, and then finish with some practical takeaways at the end. So what Black Sky held is that a deficiency judgment is available to a sold out junior lien holder who is the same as the senior lien holder, so long as there was no evasive loan splitting that happened at the time that the two loans were originated. So this holding directly overturns nearly 30 years of precedent. So how did we get here? California Code of Civil Procedure 580D was a statute that was enacted following the Great Depression, and its purpose was to prohibit deficiency judgments against borrowers after a non-judicial foreclosure of a deed of trust. And so because the cases that are decided in this area of the law, they specifically talk about what the statute said, so I think it's worth reading this here. So just to paraphrase, what 580D says is that no deficiency shall be owed or collected, and no deficiency judgment shall be rendered for a deficiency on a note secured by a deed of trust, in any case in which the real property has been sold by the trustee under power of sale contained in the deed of trust. So the first case that looked at 580D in the context of junior creditors was a case called Roseleaf Corp., and that was from 1963. And this is the case that created what's known as the sold out junior rule. So in that case, there was a senior loan and a junior loan, and those two loans had different lenders. So unlike Black Sky, different lenders. The senior lender foreclosed in Roseleaf, and the junior lender then sued the borrower for a deficiency judgment on its junior loan. And so the borrower raised 580D as a defense, saying that 580D, prohibiting deficiency judgments, prohibits the junior lender from personally suing the borrower on the junior note and getting a deficiency judgment. So the question here, really before the court, is whether 580D applies across multiple tiers of liens. And remember, Roseleaf had different lenders. And what the court in Roseleaf said is that the plain language of 580D, it indicates that it only applies to a particular note and its associated deed of trust. Remember, but the language talked about in 580D says a note secured by a deed of trust. But the court also said that the junior lender's fate should not be at the whim of the senior lender. So if the senior lender forecloses, it shouldn't be able to take away any remedy whatsoever that the junior lender might have. And so that gave rise to the sold out junior rule. And so really, just to think about this for a second, Roseleaf really had two independent reasons as to why they permitted the junior lender from seeking a deficiency judgment. Number one, because of the plain language of the statute. And number two, because the court viewed it as inequitable for the junior lender's fate to be determined by the whim of the senior lender. So again, that case was in 1963. That was a California Supreme Court case. And then time moves on, and in 1992, the California Court of Appeal took up a case called Simon v. Superior Court. And this is a situation where the senior lender and the junior lender are the same lender. the same entity. So Simon was a case where the senior lender made its senior mortgage loan, and then 6 days later, it made a junior mortgage loan. Time went on, the borrower started having problems, so the lender foreclosed on the senior loan. And then after that, the lender tried to obtain a deficiency judgment on the junior loan. And relying on Roseleaf, the junior lender tried to argue that it was a sold out junior and it should be able to obtain a deficiency judgment. But what the Simon court actually went in a different direction, and it latched on to that second point in Roseleaf. So not the plain language point, but the point about the junior lender's fate being at the whim of the senior. And what the court said in Simon is that, well, since the junior lender is the same as the senior lender, the junior lender is in charge of its own fate. So that was the risk of the junior of that lender by foreclosing its senior loan, and it should have known that it wasn't going to be able to seek a deficiency judgment on the junior. So the rule from Simon is you can't make yourself a sold out junior if you own both the senior loan and the junior loan. And that rule in Simon, that persisted for 30 years, nearly 30 years, up until late last year. And that's where the case Black Sky Capital came. And again, this is a California Supreme Court case. And so what happened in Black Sky is Citizens Business Bank made a loan to the Cobbs, which are two individuals, and that was secured by a first priority deed of trust on their commercial property. And then 2 years later, that same lender, Citizens Bank, it made a second loan to them, and that was secured by a second priority deed of trust on that same property. Down the road, an entity called Black Sky Capital purchased both the senior loan and the junior loan from Citizens and foreclosed on the senior loan. After foreclosing on the senior loan, they then sued the borrower for a deficiency judgment on the junior loan. And the borrowers quickly filed a motion for summary judgment saying, hey, you clearly cannot do this. Look at Simon. Simon says that if you're the same lender on both the senior and the junior loan, you can't make yourself a sold out junior. And the trial court granted that motion for summary judgment, and the borrowers appealed, and the Court of Appeal reversed. And after the Court of Appeal reversed, of course, the borrower appealed again, and the Supreme Court affirmed. And the Supreme Court spent a lot of time explaining its reasoning. So what the Supreme Court said in Black Sky is that, first of all, 580D clearly relates to a single deed of trust. So remember, the first point that was discussed in Roseleaf is that it's a deed of trust securing a note. And that Simon really expanded 580D to cover multiple deeds of trust. But the court recognized that, especially in modern finance, people come up with creative structures to try to circumvent certain protections. And so the court recognized that Simon's holding was most likely motivated by the court trying to prohibit structures that were created for again, something that was created following the Great Depression, and it had a lot of legislative history and importance among the community. The technical difficulty there. Okay, so what the court held in Black Sky was that as long as the facts do not indicate that the junior and the senior loans exist as a result of some evasive loan splitting, then the junior lender can recover a deficiency judgment. So remember in Black Sky, the loans were made 2 years apart, and there was no evidence of any evasive loan splitting, unlike Simon, where the senior loan and the junior loan were made a few days apart. We have 2 years of separation here, and the court didn't identify any other potential evasive loan splitting happening. So again, the rule from Black Sky is now that a junior lender who is the same as the senior lender can seek a deficiency judgment on the junior note after foreclosing the senior loan, even if it's the same lender, as long as there's no evidence of evasive loan splitting. So where's this going to head in the future? Probably people are going to argue about what constitutes evasive loan splitting. We know that loans that were originated 2 years apart, like in Black Sky, that's probably not evasive loan splitting, but loans that were originated within 6 days, those probably are going to be an evasive loan splitting situation. So I just want to talk quickly about 4 practical takeaways here. Some of them are more practical than others. So first, with respect to residential real estate finance, and also to a degree in commercial, but more primarily in residential, Black Sky is likely to increase the value of junior notes on the secondary market. To what degree it remains to be seen, but it probably will to some amount. And so think of the situation where a buyer of debt goes to the secondary market and looks at the various loans that are available for it to buy. Before Black Sky, a lender, if it was savvy and that knew of Simon or just knew that it shouldn't be doing this, that it would, if it saw that that lender or maybe its affiliates owned the senior loan to which the junior loan related to, it wouldn't buy that loan because it would be afraid that if it tried to foreclose its junior loan after foreclosing the senior loan, it wouldn't be able to collect a deficiency judgment because of Simon. So the fact that that is no longer an issue, that means that there are more lenders out there who could potentially buy any given loan. So second takeaway is with respect to the commercial space. So the most significant commercial estate loans utilize special purpose entity structures. Black Sky is less likely to come into action there because typically the only asset of an SPE is the real estate that the senior has its lien on. But I'll give an exception in a minute here. Where Black Sky is directly implicated is relationship banks who often make mortgage loans to operating companies, where the mortgage loan is only a small piece of the business with the borrower. So that you could have a bank that has a huge business line with a particular borrower, and the borrower wants to mortgage its property, and so the lender says, "Oh yeah, we know you. We'll give you a mortgage loan." And so you now have a situation where a bank is willing to make a junior loan on a company that may have assets in addition to the real estate that secures the senior loan. And then that relates to also this third takeaway, is that you might see an uptick generally in junior loan originations because relationship lenders, they already know their borrower, and they might be able to fast track a loan knowing that it's potentially collectible, especially if loans to operating companies. And then the fourth takeaway I wanted to mention is in a bankruptcy context. So if you have a situation where a borrower group is heading into trouble, with the Black Sky holding, what you now have is a potential significant additional unsecured junior creditor. And that would be the junior creditor who would be holding a judgment against the borrower, a deficiency judgment because the senior loan was foreclosed and it was a sold out junior. And so this could be particularly significant if the borrower's organizational structure is substantively consolidated, and you could all of a sudden be in a situation where there are many other assets in addition to the borrower's assets that you made the loan to. And so this will be something to keep an eye on as bankruptcies play out in the coming future. So I'll go ahead and turn it over to Ira to talk about some updates in the area of usury law.
May I
Or
offer a comment on this?
yeah,
before?
Ira and Scott may have some additional thoughts as well.
Please.
May I offer a comment on this, please?
Sure.
So it's the most, if we have 100 people on this call right now, I'll bet there are 25 instances at least where somebody has a mortgage on their house, and they also have a line of credit secured by a mortgage. So it's a HELOC, home equity line of credit. And it's the most common thing for a homeowner to have a mortgage and a HELOC. And they are oftentimes originated on the same day. And so there's no intention of circumventing the anti-deficiency laws. You want a 30-year fixed rate on your main mortgage, and you want to have some money available, say for 5 years at prime +1 or maybe prime -1 on your HELOC. Those are two very different loans, but they're secured by the house on the same day they're originated. I'm going to just guess that there are many hundreds of thousands of these in California, maybe millions of these in California. And up until the Black Sky case, Simon ruled, and Simon said that that homeowner is not going to have to suffer a deficiency on the HELOC loan. And now there's the possibility that the borrower will suffer a deficiency judgment on the HELOC loan. It's different. It's a big difference. And I'm guessing that the Supreme Court wasn't thinking about homeowners and wasn't thinking about the prevalence of this particular structure. And I wouldn't be surprised if years from now, the Supreme Court makes an exception for that.
Excellent point, Scott.
You know, what the Black Sky case just really, to me, is a strange one, but I've come to expect that out of the California Supreme Court. I mean, I can't say that Simon was right, but it was the law for a long period of time. And if you trace the history of the cases, even before Simon and then after Simon, the last case before Black Sky was the Kettle Rock case, which we talked about a couple of years ago. And in that case, surprising to me, there were two loans made to the same borrower, and they were sold to different lenders. The junior was sold into a pool for securitization 10 days after the funding of the loans. The senior was ultimately sold after foreclosure was filed, but before the foreclosure sale. So at the time of the foreclosure sale, even though the loans originally were made by the same lender and seemingly Simon would apply, because at the time of the foreclosure sale, the loans were owned by different lenders, the Simon rule did not apply. And when the senior completed its foreclosure sale, the junior was treated as a sold out junior under the Roseleaf case. So the rule seemed to be before Black Sky that it didn't matter what happened at the origination of the loan. It only mattered what the situation was at the time of foreclosure. Now, whether or not that made any sense or not, it didn't to me, but that seemed to be the rule. Black Sky sort of overturns that and says, basically, it doesn't really deal with the situation of the lenders being different at the time of foreclosure sale because it was the same lender. But it seems to indicate that no matter what, you're going to be a sold out junior unless you had this evasive intent at the initial stage of the loan. So I'm not sure Black Sky is necessarily correct. I'm not sure it's the final word. As Alex pointed out, there are many other situations that could arise, and it's hard to say exactly where it's going to lead.
All right. Well, with that, Ira, why don't you walk us through the new developments in usury, And then we're certainly running a little long on time here, but I think that is important for everyone to hear. And then we'll see if we can do something in the way of a lightning round toward the end.
Okay. As far as the usury goes, yeah, I was sitting in my office a few months ago, and someone came to me and said, there's this case out there that could create a problem with our situation. And their situation was they had a construction loan for a home that was a certain interest rate, and subsequent modifications and forbearances of that loan at a rate that would exceed the 10% usury rate. And each one of those modifications and forbearances was arranged by a licensed real estate broker, as was the original loan. And some other attorney had advised them that could be a problem because of this In re Archie Riverside case. And I said, well, what are you talking about? The loan was arranged by a licensed real estate broker, and each of the forbearances was arranged by a licensed real estate broker. Why would there be a problem? He said, well, take a look at the case. So I looked at the case, and it turned out that, yeah, there could be a problem. Now, the case wasn't directly on point because the original loan was not a loan made or arranged by a licensed real estate broker. It was made by a California finance lender. Okay, so I looked at that, and that loan was ultimately sold to somebody else, and then the forbearance took place. This is in the case. And so I go, okay, well, what's wrong with that? And basically, the case said it never dealt with the finance lender's law particularly. It dealt with the broker arrange aspect of it. And it looked at the civil code section that supposedly enhanced the constitutional amendment usury exemption provision, and said there are only two limited instances of forbearances that could be arranged by a licensed real estate broker. And this situation did not fit. And I scratch my head and go, well, let me go look at that. So you go look at that and you go, yes, that does seem to be the case. But what about the fact that the loan was made by a finance lender and then sold to somebody else? What should be the situation as far as that goes? Well, let me share my screen for just a minute here. Okay, this is the constitutional statute. And the problem is that the language isn't great, and the statutes that add additional lenders is not great either, and it's very confusing and can lead to unusual results. It starts out, the usury restrictions won't apply to any obligations of loans made by or forbearances of any building loan association, and then continues to say, or to any corporation. Not to any loans, not to any obligations of loans made by or forbearance of, but to any corporation. And then stuck in the middle is, or any loans made or arranged by a licensed real estate broker and secured by real estate. Not loans or forbearances, which creates the problem, but to the loan. Okay. Then you get all the way down here and it says, or any other class of persons authorized by statute, or to any successor in interest to any loan or forbearance exempted under this article. Okay. Finance lenders. To accomplish its underlying purposes, this division creates a class of exempt persons pursuant to the Constitution. Okay. Well, if in the In re Archie case, the lender was a finance lender, an exempt class of persons, and you go back to the constitutional amendment, and it says the restrictions don't apply to any successor in interest to the loan or forbearance exempt under this article, then why in the In re Archie case does the exemption not go forward with the purchaser? If the purchaser is a successor to an exempt loan, should be an exempt lender in that case, and should be able to modify that loan and the interest rate exceed the usury rate and be exempt. Well, it's never even discussed in the In re Archie case. So I'm personally flummoxed by how broad the successor in interest provision is in the constitutional amendment. And why is that important? It's important because many of the loans that are subject to forbearance now in this time of the pandemic are loans that were not originally exempt or because they were not made by an exempt lender. They may have been arranged by a licensed real estate broker and then transferred. So how far does this go? And the language in some of these statutes is very confusing. In the finance lender statute, creates an exempt class of persons. But in the sophisticated parties usury exemption, it's a class of transactions in persons. Well, is that a difference between that and creating a class of exempt persons? And then how does that all relate to the successor and interest provision? And it all gets worse when you get down to the real estate broker arranged loans and forbearances. Remember, the constitutional amendment only applies to loans. The statute says, shall not apply to any loan or forbearance made or arranged by a licensed real estate broker. Man, if they stopped there, it wouldn't be a problem. A broker could come in and arrange the forbearance, no problem. But unfortunately, it goes on to say, for purposes of this section, a loan or forbearance is arranged, blah, 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 and lists different categories, none of which are the more typical situation of a loan originally made or arranged by a licensed real estate broker, and it's being modified and a forbearance being entered into. So time won't permit me to go through all this, but it means you have to really read this stuff carefully. And there are other possible rationales for why you may not have to worry about forbearances of originally broker arranged loans. And the materials go through all those possibilities, but the problem still is, can you be sure? Can you be sure? If you enter into a forbearance and ultimately the rate's going to be higher than 10% because of fees you're charging, because of back-end interest, because of negative amortization, will the loan retain its exemption as a result of that forbearance, whether or not it's arranged by a licensed real estate broker? The statute is just not clear. I've given the materials plenty of reasons why it should be, but I can't tell you I'm 100% sure.
And Ira, what happens if it's not?
Well, that's an interesting question. If it's not, would you need to go back to the original loan and have to regurgitate interest paid from the beginning? Probably not. You'd probably have to regurgitate any interest that's charged as of the time the forbearance was entered into. And of course, you've got the potential risk of having to pay treble damages, which is rarely implemented by the courts. So that's your risk. Your risk is loss of the interest.
So when this is likely to come up is after the forbearance runs its course and the loan hasn't been repaid, and the lender seeks to exercise remedies and the borrower raises this as a defense.
Yeah, the borrower who may not even know that it had a problem, suddenly somebody says, hey, did you check and see if there might be a usury issue?
Yeah.
And what are you talking about? And sure enough, they'll go look and go, there is this case out there that says this could be a problem. And okay, let me challenge this. Why not? As the president sometimes says, what do you got to lose?
So there's settlement value in it.
There's certainly a settlement value in it. And given the confusion in the cases and the language of the constitutional amendment and some of these statutes, yeah, there is settlement value in it.
All right, Ira, if you will unshare your screen, I was hoping to give the last couple of minutes here. Amanda, I think it's important if you can just highlight quickly the reinstatement cases. As I'm guessing there are going to be a lot of loans in default and they're going to want to know their reinstatement rights before foreclosure.
Yes. So California Civil Code Section 2924C mandates that a borrower can cure a default under a deed of trust within a certain period of time, terminate the foreclosure process, and receive a fresh start. So as opposed to the equity of redemption, where you have to pay off the entire loan, in order to reinstate your loan, you only have to pay the amounts then in default. This only applies to monetary defaults. So there is a recent case, Taniguchi v. Restoration Homes, LLC, where the borrowers entered into a loan, later modified the loan, and then defaulted on the payments. In the modification agreement itself, it provided that the lender would have the right to enforce the loan according to the original terms if there was a default under the modification agreement. So this kind of sounds like that the right to reinstate was waived and that they would have to pay everything off. So Section 2953 of the California Civil Code provides that the right of reinstatement cannot be waived in an express agreement made or entered into by borrower at the time of or in connection with the making of or renewing of any loan. So the lender argued that since in the modification agreement, they said that they could revert back to the original terms, the borrower had to pay everything off to reinstate. The borrowers argued that they can't waive that right. So when they modified the loan, it was the renewing of a loan and they only had to pay the amount in default since the modification. The court did find that the modification was a renewing of a loan, so the Taniguchis could not waive their right to reinstatement in that modification agreement, and they therefore only had to pay the amounts in default after, not everything beforehand. There was another case, Earlene Williams v. 21st Mortgage Corporation, where the plaintiff filed for bankruptcy, and the bankruptcy plan required the plaintiff to make monthly payments to cover her pre-petition mortgage arrears. When the plaintiff attempted to make her payments, the lender demanded not only the amount under the plan, but also all pre-petition arrears also. The court found that the amounts on which payments are being made pursuant to a confirmed bankruptcy plan are not in default, since the bankruptcy plan altered the plaintiff's obligations, and therefore they made those pre-petition arrears not then due, which is what the borrower is required to pay in order to reinstate the loan. So both cases just show the right of reinstatement provides the debtor with the right to reinstate the loan by tendering payment of just the amount then due to cure the default, rather than any other amounts.
And I would like to point out from personal experience that California is quite unique in having this reinstatement right. And working with loans through many other states, that once the lender calls for acceleration and a default notice, you're done. You either pay off the loan or you're foreclosed out. California, by statute, has this reinstatement right up until 5 days before a non-judicial foreclosure. And it sounds like it's not waivable unless you just randomly go to your borrower at a time when you're not otherwise modifying the loan and ask them to waive it, which who's gonna do that?
Right.
So anyways, I'm just gonna take one more minute and tell you about one other case. It's the case of Handouche v. Lease Finance Group. And super quickly, it basically gives contracting parties who want to have forum in another jurisdiction two choices. If you want jurisdiction in another, or if you want forum in another jurisdiction, don't include a jury waiver in your contract, or you're going to be stuck in California if you're contracting with a California party. Otherwise, if you don't mind being in California and not being able to waive the jury, have at it. But that's just the takeaway point. So with that, I noticed, we're clean on chats and Q&A, and we're at 1:30. So you have our materials. You can certainly feel free to contact us otherwise with any questions over what's in the materials as well. And we very much appreciate you all being here for our presentation.
There really is a lot in the materials.
Yeah.
Remember, we were supposed to do this program before the pandemic arose, and it was supposed to be an hour-and-a-half program, and we had enough material to do an hour-and-a-half. And then you add in the pandemic stuff, and they took away a half hour of our program. Obviously, we couldn't get to everything, but the materials are pretty good. And if there are any, like as Owen said, if there's any questions about anything in the materials, feel free to contact us.
Thank you very much to our great panel, Amanda, Owen, Alex, Scott, and Ira. As far as administrative stuff, I think there's another seminar coming up on July 9th on loan modifications. If anyone's interested in that, I would check the LA County Bar Real Estate Section website. And thank you very much, everyone. Have a great day.